So I have an important update in the California ammo ban case. So let's talk about what is happening. Now, really quick before we jump into this video, I want to ask you guys for a huge favor. Looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you want to support this channel for free, please consider subscribing to the channel. Also, click the notification bell and turn on all notifications, because that is one way to ensure that YouTube will actually send you these videos. And I also want to thank one of the main supporters of the channel, which is 1st Phorm. 1st Phorm, of course, is an amazing company. They're pro-2A, pro-freedom. 1st Phorm is going to have a ton of sales. So if you're interested, check them out using my link down below. And if you use my link and you order anything over $50, you will get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, I have a very important update in the California ammo ban case called Rody versus Bonta. Many of you may recall that recently the District Court Judge, Judge Roger T. Bonitz, struck down the California ammo ban with a permanent injunction, and that was a final merits decision. In that decision, Judge Bonitz found that the California ammo laws did in fact violate the Second Amendment and also were not consistent with the recent 6-3 decision that was issued by the Supreme Court in Bruin. He found that clearly the California ammo ban did not align with the text, history, and tradition of the Second Amendment, and therefore he struck it down entirely. However, after that decision, the Ninth Circuit put the restrictions in California back in place because the state of California appealed those up to the Ninth Circuit. Many of the California Second Amendment cases which are pending in front of the Ninth Circuit have stalled out, but Rody is one of the only cases that's moving forward, and now oral arguments are set to take place next week. This is a critical hearing that everyone in California has been waiting for, so we need to talk about what are the implications here and what is going to happen. Now, if you're not aware, Rody versus Bonta deals with the state of California's restrictions on the purchase of ammunition and also the background check systems that are currently in place if you want to purchase ammunition. This provision was passed through Proposition 63, and now you are required to go through one of two background checks every single time you purchase ammunition. There is the basic eligibility check and then also the standard eligibility check, all coming with different fees that you have to pay to acquire ammunition. There's also the general California law where you have to purchase ammunition through a licensed dealer and go through a background check. You could not order online and then have it shipped to your home like a lot of other states. In other states, you can order online and have it shipped to your home. There are some exemptions in the state of California, like if you have a COE and FFL 03, but for just the general average person who doesn't have those exempt statuses, you would have to go through a FFL, do a background check, and do all those things to acquire ammunition. So that's the law in question, which is being challenged in Rody. Judge Roger T. Bonitz, or Saint Bonitz as he's known in California, has actually reviewed and ruled on this case twice. On original review of this case, Judge Bonitz utilized what can be best described as a version of text as informed by history and tradition, because this was prior to the Supreme Court's 6-3 decision in Bruin. So Bonitz did exactly what the Supreme Court wanted him to do even before they issued Bruin. Bonitz applied text as informed by history and tradition to find that California's ammunition restrictions were in fact invalid. Now, after that original ruling, the state of California then appealed that decision up to the Ninth Circuit. Oral arguments originally in that first decision, in that first review, were held back in November of 2020. And again, that was in front of a 3-judge panel. But the ruling of that panel was put on hold because the Supreme Court was set to rule in Bruin. Now, after the Supreme Court ruled in Bruin, the Rody case, along with a bunch of other California Second Amendment cases, were remanded back down to Judge Bonitz for him to reconsider them and re-rule on them in light of Bruin. And that's exactly what Judge Bonitz did, and he pretty much issued the same decision, but even stronger, because now he had, affirmation from the Supreme Court that his prior text as informed by history and tradition standard was proper and he did it the right way. So he pretty much got to issue the same decision, just even stronger. The decision of Judge Bonitz lifted the background check requirements in California and also all of the importation restrictions. That meant because of that decision, California gun owners could once again go buy ammunition without going through a background check, and they were once again able to purchase ammunition online and have it shipped directly to them to their front door. But as we all knew, California was not going to let that sit. Once the news broke, a lot of companies started to sell ammunition to people. People were buying it and they were getting it shipped to their home. But again, California responded by appealing that up to the Ninth Circuit, They wanted a stay from Judge Bonitz. They wanted to have a 10-day stay of his decision. Judge Bonitz denied that. They went to the Ninth Circuit and also sought an emergency stay. But interestingly, the Ninth Circuit motions panel did not move on that immediately. It actually went through the weekend and went through a few days, which allowed people to purchase ammunition online, legally, lawfully do that before the Ninth Circuit stepped in and issued their own stay on the decision. So the Ninth Circuit granted the emergency stay on the Bonitz decision, and then they granted the appeal in this case. And then briefs and amicus briefs have been filed to the Ninth Circuit arguing why this ammunition ban in California is either valid or invalid. Now, recently, the state of California also submitted a supplemental authority letter to the Ninth Circuit, and they argued that the recent Maryland assault weapon ban decision in the Fourth Circuit, which is the Bianchi case, that case and that ruling supports upholding California's ammo ban. In the letter, the state of California argued that appellant rights to notify the court of the Fourth Circuit's en banc decision in Bianchi versus Brown. The Fourth Circuit considered a Second Amendment challenge to a Maryland law banning so-called assault weapons. After rejecting plaintiffs' facial challenge because plaintiffs failed to show that each firearm regulated by the Maryland statute is within the ambit of the Second Amendment, the court considered the constitutionality of Maryland's restrictions on AR-15s. The court applied Bruin's two-step methodology and concluded at the first step that the covered firearms are not within the scope of the constitutional right to keep and bear arms for self-defense. The court further held that even if the text of the Second Amendment were read to encompass the covered firearms, the statutory provisions would nonetheless be constitutional because Maryland's ban on AR-15s is consistent with a strong tradition of regulating excessively dangerous weapons once it becomes clear that they are enacting an inordinate toll on public safety and societal well-being while nonetheless preserving avenues for armed self-defense. So California is trying to use that supplemental letter in the recent decision in Bianchi, which used the improper military use analysis to essentially uphold what is now happening in California with the ammunition restrictions. In Bianchi, the Fourth Circuit en banc panel argued that in their belief, AR-15s and similar rifles are useful in military service, and since they are militaristic weapons in their eyes, a state can ban them as dangerous and unusual. The Fourth Circuit also relied heavily on the public interest approach that, kind of backdoored in a type of analysis already rejected by the Supreme Court in Bruin. Bianchi and its analysis are highly questionable in my opinion, and in fact, currently they're up for reversal and review in the Supreme Court. The Supreme Court, is considering these and potentially is also going to hold conference on them before the end of this year. The plaintiffs in Bianchi are asking the Supreme Court to review the Fourth Circuit decision, and ultimately they hope that it will be reversed, and ultimately all these rifle bans will also be struck down. But now all of this is kind of coming to a head with oral arguments that are now set to take place just next week on December 4th in the Rhodey ammo ban case in California. The Ninth Circuit will hear arguments on the constitutionality of this ammo ban, and the three judges which are going to rule on this case, that are going to decide this case and hear these arguments, are Judges Bybee, who is a Bush appointee, Ikuda, who is a Bush appointee, and Bade, who is a Trump appointee. So the draw of judges is not the worst, but it's also not the best. I know that Ikuda, she's been very pro-2A in the past. She's issued rulings in dissent multiple times when the Ninth Circuit was upholding various laws like the California magazine rifle bans. She wrote dissents saying that those were clear violations of the Second Amendment. She's been very pro-2A, so I kind of know her track record. However, when it comes to Judge Bybee, he's not got a great record. He authored the 2021 majority opinion in the Young versus Hawaii case, which upheld the state of Hawaii's CCW permit restrictions. Those restrictions required an urgency or a need to get a CCW. Judge Bybee, in that opinion, found that a general desire for self-defense is not enough of an urgency. Therefore, he and the majority upheld the Hawaii restrictions on CCWs. Now, all of that was back, I believe, in 2021. That ruling came out in 2021. That was before the Bruin decision in 2022, where the Supreme Court found under Bruin that self-defense is enough of a good reason to get a carry permit. Therefore, the prior decision of Bybee in that Young case was then GVR, which means it was granted, vacated, and remanded by the Supreme Court in light of Bruin, saying you got this wrong, you were clearly wrong, these types of restrictions do violate the Second Amendment. So I wanted to give you that little extra information on some of these judges so that going into the oral arguments, if you want to listen, you will know maybe some of their track record and maybe where they will be leaning on these issues. I also want to note that the order of the panel states that they may decide to submit this case on the briefs, which means that they may decide on their own that they don't want to hold oral arguments next week. Instead, they might want to review the briefs and decide the case just on the brief. So they noted that in the order. So although the oral arguments are set for December 4th, they also noted that, hey, we might just take this on the brief. So we're going to be, watching that to see potentially if they decide to do that. So if you guys like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help to fuel the algorithm. It signals to YouTube that you guys see value in these videos. Also, I just wanted to wish everybody a happy Thanksgiving. I know a lot of people are traveling during this week, doing a lot of things with family. Enjoy your family time. This is, one of the amazing things about our country, that we get to enjoy, amazing times with our families. So again, be safe out there. Enjoy your time, enjoy your freedoms. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.